Welcome, everybody. My name is Edward Iacobucci, and it's my privilege to be Dean of the Faculty of Law here at the University of Toronto. It's also my privilege to welcome everybody today to hear some remarks from Attorney General Yasir Naqvi. A little background, many of you are familiar, I won't be long, but the Attorney General was born and raised in Pakistan, and his father was a successful lawyer who risked a great deal and ultimately paid a significant price in pursuit of justice. He was arrested for leading a pro-democracy march, and eventually their family left the country for the safer environment of Canada. It's a testament, I think, to him and to his family that only a few years later he is one of the public officials who is crucial to upholding the rule of law in this country. He has been a friend to our faculty, and we've appreciated him coming here on a couple of different occasions, including most recently speaking to our incoming students about his upbringing, about his experience, how it shaped his worldview, and about how working as a lawyer, even when you may not be aware of it, about how working as a lawyer can lead to positive social change. Minister Naqvi attended McMaster for his undergraduate, Carleton University for his master's, and the University of Ottawa, where he obtained his LLB. As I mentioned to my students earlier, you can't have it all. After practicing for a little while, he successfully ran for office in Ottawa Centre in 2007, has been an MPP since then. He's had various significant portfolios, including Minister of Community Safety and Correctional Services, Minister of Labour, and now Attorney General. So we're delighted and honored to have the Minister here with us again today. Minister.
Thank you very much, Dean, for that kind introduction. We won't belabor the point that I did try to get into your law school, but I wasn't good enough for you. So just leave it at that. I've shared the story in the past here before, but it is wonderful to be back at University of Toronto Law School. So thank you for your kind hospitality. Before I begin, I would like to acknowledge Toronto as a sacred gathering place for many Indigenous peoples. I wish to recognize the long history of First Nations peoples in Ontario and show respect to the Mississaugas of New Credit. Ladies and gentlemen, it was almost 1 year ago today that I stood here in this very spot to announce a plan for bold changes to our criminal justice system. That plan, as many of you know, was our response to the Supreme Court's Jordan decision. The top court told us that there was a culture of delay and complacency in the justice system, and that everyone from elected officials to the courts, the bar, and police all had a role to play in it. It has been a long and at times tough year in the aftermath of that wake-up call. We have seen cases tossed because of delay, leaving victims, families, and communities angry and frustrated. And though the Jordan decision has been difficult for many, it has also presented us with an opportunity, a once-in-a-generation opportunity to come together and make meaningful and lasting structural reforms to our criminal justice system. I believe we have seized that opportunity. Together, we have made important progress in the ongoing work to reduce time to trial and increase access to justice. Last year announced significant and sustained funding for Ontario's criminal justice system, an additional $25 million a year, to be exact, to appoint more judges, hire more crowns, and increase funding to legal aid. Importantly, part of these resources went to greater community support and supervision for vulnerable, low-risk people, including Indigenous peoples and racialized individuals, and those with mental health and addiction issues who, as we know, are vastly overrepresented in our criminal justice system. We took a thoughtful approach to this challenge. First, we put resources into building community capacity and supports. But ultimately, we knew that lasting and meaningful change would require more than resources and support programs. It requires structural changes. Now, let me be clear that there are some people who pose a risk to public safety and should rightly be denied bail. But for those people who are low risk and may just need a bed to sleep in, that is where Ontario can step up and help. People should not be denied bail by the simple virtue of their disadvantage. I want to thank those of you here who partnered with us to make these supports a reality. There are communities all across the province now benefiting from your work. It is because of those enhanced supports that we are able to be here today talking about significant changes to Ontario's approach to bail. As part of our plan, we enlisted the expertise of 3 prominent bail advisors: former Chief Justice Brian Lennox, former Deputy Attorney General Murray Siegel, and former Deputy Crown Attorney Laurie Montague, now an Ontario Court of Justice judge, to provide advice on modernizing our Crown policy on bail. At the same time as this expert review, the Supreme Court of Canada was grappling with similar questions, which culminated in the Antic decision earlier this summer. Antic sends the justice system an unequivocal message. It is a clear reminder that at the bail stage, save for some exceptions, an unconditional release of the accused should be the default position. In this decision, the Supreme Court spelled out the latter principle for us, which in practice means starting at the bottom rung, the least onerous form of bail, and considering it before rejecting it and before moving up the ladder. The Antic decision may not have set out prescribed timelines like Jordan, but in many ways, it is a similarly critical wake-up call. And just like the Jordan decision, tackling this challenge will require all of us working together to change the way we approach bail matters. Bail is a critical stage of the justice process, and whether or not a person has access to bail can have serious impacts on the outcome of their case. This first entry point into the criminal justice system often defines people's overall experience. Simply put, lengthy pretrial custody and unreasonable bail orders are not in the best interest of Ontarians. As the Supreme Court wrote in Antic, and I quote, "Pretrial custody affects the mental, social, and physical life of the accused and his family, and may also have a substantial impact on the result of the trial itself." End of quote. I do not take this reality lightly, having seen the overcrowding in our correctional institutions firsthand, as many of you have done so. I think we can all agree. Too many of the people in our province's correctional facilities are on remand, more than people actually convicted of an offense. Too many are vulnerable, low-risk people, or those with mental health and addictions issues. Too many are detained for breaching conditions. And far too many, a disproportionate number, are racialized or Indigenous. Many of these individuals end up in remand because they do not have the social or financial supports necessary to get or stay out on bail. For some, it's an ongoing cycle. And for many, remaining in the system can impact their ability to earn an income and interrupt the care and support they need. As a province and as guardians of our justice system, I know that we can and must do better. And as the Supreme Court correctly pointed out, the stakes are too high for anything less. We knew that to address the challenges around bail, we needed greater resources and alternatives in the community, but also to shift the culture. This is the task that our bail advisors took on. Specifically, I directed them to draft a new bail directive for Crowns that would consider the latter principle and the principle that an accused, when released, should be released on the least restrictive bail possible, appropriate to the circumstances. That restrain in the use of sureties and conditions, the Gladue principles, and the recommendations from Justice Wyant's report on bail and remand, the Justice on Target Bail Experts table reports, and recent reports from external organizations and academics on bail, among other things. The bail experts traveled to Kenora and Thunder Bay to hear directly from Indigenous communities and to understand the distinct concerns and perspectives of Northern and fly-in communities with respect to bail. And they met with the legal community, community-based organizations, prosecutors, and ministry staff to get their advice to inform our revision of Ontario's bail directive. They reviewed expert and academic reports on bail, and they provided their advice to me. So I'm very excited to announce today that we are releasing a new bail directive to make the bail system faster and fairer, while balancing the need to protect the safety of victims and the public. It takes the message delivered by the Supreme Court and expert reports and translates it into practice. We are grateful to former Chief Justice Brian Lennox, former Deputy Attorney General Murray Siegel, and the now recently appointed Justice Laurie Montague for their valuable insight and incredible work on this important task. The new bail directive will aim to reduce barriers faced by Indigenous and racialized communities at the bail stage, ensure that low-risk and vulnerable individuals have access to the appropriate supports for safe releases, and speed up the bail process. It sets out with clarity Ontario's renewed approach to bail in a post-Antic world. The new directive says clearly that bail recommendations should start with the least restrictive form of release, the latter principle, and that having an accused person released with a surety should be the exception, not the rule. Importantly, it reinforces that recommendations for conditions of release should be connected to both the circumstances of the accused and the facts of the case, while at the same time meeting public safety concerns. But based on recent expert reports and the strong declaration from the Supreme Court, we know this is not always the case. And the result has been an increasing number of breaches of bail conditions, which contributes to clogged courts and overcrowded correctional institutions. It is now clear the default position will be restrained in use of sureties and conditions. The directive also highlights the requirement to take into account the unique circumstances of Indigenous peoples and the barriers faced at the bail stage by vulnerable and disadvantaged accused, including those who are racialized and socioeconomically marginalized. I believe that these new standards respond to Antic and Jordan and set out a progressive policy for bail in Ontario. Importantly, the directive emphasizes the use of community-based programs as alternatives to detention, because we know that when individuals are connected with appropriate resources and supports, they are more likely to achieve stability in the community and less likely to reoffend. This is the exact foundation that we have built over the last year. We can now recommend the least restrictive form of bail without impacting community safety, because the appropriate supports for accused are there. And if you'll indulge me for a moment, I'd like to tell you a little bit about some of that work. Our pilot bail batch program is providing safe, accessible, supervised housing in 5 communities across the province. These programs provide support and supervision for vulnerable accused people with complex needs, people who require extra help to be able to access bail. Across the province, we have enhanced and expanded the bail verification and support program. It means that low-risk, vulnerable people who might otherwise be in custody awaiting trial can now have the extra supervision and support they need. The enhancements include supporting people with mental health issues and expanding Indigenous bail services. And I'm pleased to share that our bail supervision programs have seen an almost 45% increase in uptake. That means more people getting the support they need in the community. In addition, we have established a number of new Indigenous bail verification and supervision programs designed and operated by Indigenous organizations and communities to deliver Indigenous-led, culturally relevant and responsive programs to Indigenous peoples. And in the locations that have enhancements to Indigenous bail services, I'm pleased to say that there has been a 60% increase of Indigenous people accessing these supports. It means that 60% more Indigenous accused are accessing supports that allow them to stay in their communities when they may otherwise have been denied bail. The new bail directive and our increase to community supports work hand in hand. Together, they allow Crowns to recommend less restrictive bail conditions with the knowledge that accused are still being supervised and that our commitment to public safety is maintained. As Attorney General, it is my responsibility to ensure that our Crowns have the training, resources, and most importantly, the support of the Ministry of the Attorney General as we move forward in this new era of bail. Crowns are on the front lines of the justice system. They have to make difficult decisions every day. In releasing this new directive, I want them to know that they have my support when they make these decisions. While we are here today to mark our one-year progress, it is important to recognize that this work is ongoing. We have heard loud and clear from the Supreme Court with the Jordan and Antic decisions that our work is not finished. We are moving forward to modernize how bail and pretrial custody will work in Ontario. I strongly believe that Ontarians should have equal access in our justice system regardless of their income, where they live, their ethnicity, or gender identity. So we will continually work and move towards a criminal justice system that serves the best interests of all Ontarians, to have a faster, modern, and accessible justice system. Thank you very much for your attention, and of course I'm here to take questions that our media friends may have.
Can you explain a little bit more about how these policies differ from the current policies? Isn't least restrictive form of release already a general policy or principle?
Well, if you look at our current bail directive, which will be no longer valid once our new directive comes into effect on November the 14th, you will see that there is a substantive difference in the approach that we've asked our Crowns to take. Our current policy focuses significantly on risk aversion. It speaks of some inquests where public safety concerns have been raised, as opposed to what we know the criminal code asks us to do in terms of the presumption of the accused being innocent and being released with the least restrictive conditions, and not to mention what the Antic decision by the Supreme Court of Canada recently reaffirmed. So we have worked hard with our bail experts to rewrite a bail directive that sincerely captures what the law is, and as a directive, then an approach that our Crowns will take with, of course, with further training and education that we also will be providing. I just want to be very clear. When it comes to an individual and accused who may be a danger to society and pose risk to public safety, those individuals, the Crown will seek that the bail may not be granted. But when we're talking about people who are low risk and vulnerable, people who have mental health or addiction challenges, people who may be racialized or indigenous, and through circumstances in their life, they are in the criminal justice system and are better off in the community setting, getting supports while they're working through the justice system. It is our recommendation through this Crown directive that those people will be released with the least restrictive or any conditions in the community.
So are you saying that the existing directive is contrary?
Well, it talks about criminal code, and of course it recognizes criminal code, but I think the focus was different in the existing policy, and I mean, it's there publicly available for you to review. I think what we know in terms of the impact of putting restrictive conditions on our criminal justice system, both in terms of the delays in our court system. It results in clogged system, and Jordan really reminds us of that. What we know in terms of overcrowding in our correctional facilities and the conditions and confinement as a result of it, it is extremely important for us that we revise our Crown policy and very clearly articulate the steps that our Crown have to take in conformity with the latter decision.
So what does this say that Antic didn't say?
Well, I mean, Antic, it's interesting, the timing kind of aligned without us knowing that Antic will come in the format it came, because you may recall last December in this room, we announced our bail action plan, building supports in the communities, also knowing that we need to revise our Crown policy so that once those supports in the community are in place, our crowns can then rely on those supports, and of course, hopefully, judiciary will allow for individuals at an increased number to be released in the community. And while this work was going on, NTIC came also, which reaffirmed exactly what our thought process was. So, for me, NTIC was a validation in the direction that we as a province needed to go, what Jordan was asking us to do, what we see the impact has been in our court system and in our correctional facilities. And we were able to, of course, merge those two together, the fact that we were doing the work and we were actually going in that direction, and of course, having the backing of the Supreme Court of Canada makes it easier. Well, so I think we talk about in the directive, looking at the circumstances of the individual. We know that we have disproportionately larger number of people who are Indigenous or racialized in our criminal justice system, people with mental health and addictions issues. We have to focus on making sure that these people get the supports they need in the community, as opposed to being remanded in a correctional facility. I have, prior to being the Attorney General, was the Minister of Community Safety and Correctional Services. I have visited many jails in our province, and I can tell you that jails is not the place where you send somebody to get better. The right care type of supports are in the community, and that's why we focus first on building those supports in the community, be it through bail beds, be it through more mental health workers through organizations like John Harvard Society, or a more expansion and enhanced version of bail supervision program. All those things allow our crowns and our judiciary to find alternative to incarceration for the accused. Recall, we've taken another important step where we have in our busy courts crowns who are bail vetters, who specialize in bail. Now they have some really clear direction as to how they can rely on supports working with the defense, be it through legal aid or private members of the defense bar, in making sure that we're getting the right supports for the individual outside our correctional facilities in the community while they're working through the justice system.
Minister, can we expect legislation on broader issues outlined in the SAPERS report to be tabled within the next 2 weeks?
So, as you know, the Minister of Community Safety and Correctional Services, Marie-France Lalonde, have announced that she will be bringing legislation in accordance with the advice that she received with Mr. Sapers. The work that we are doing here on bail, the work we're doing on reforming our Police Services Act and oversight of policing, and the work that's happening in reforming our corrections legislation, all very much ties in together, because they're sort of a different part of the spectrum or the continuity of the criminal justice system. And we're all working very closely aligned. She has committed, and I know she's working hard, and soon will be bringing legislation. I can't give you the exact time frame, but I know that the minister is working hard and will be bringing legislation soon.
Are you expanding your program of having embedded crowns in police divisions? I know you had put 2 at 51 Division in January.
Yeah, 51 Division, one in 51 Division and the other in Ottawa. It's a 2-year pilot, so we're going to focus on the pilot right now with those embedded crowns. We want to collect data. We want to see how those programs are going. Anecdotally, I've received some positive feedback in terms of the interaction between police and the Crown, in terms of what are the appropriate charges to be laid, whether the evidence is sufficient to lay a particular charge, from a disclosure of evidence purposes defense, whether the disclosure is complete or not. That's exactly the kind of things that we want to gain better understanding of. So those are 2 very important jurisdictions where we are running these pilots, and once we have the data and the analysis, we'll be able to determine whether to move forward or not.
Are those crowns providing information to police or advice on release of individuals from the police division?
So as you know, police has the discretion as well to release individuals, and they're there in the precincts to work with the police. So we have made sure that they're available to police to seek whatever advice, be it advice relating to whether or not they release somebody after laying charges, be it what is the appropriate charge based on the evidence, or around do we have appropriate full evidence for disclosure purposes, whatever that may be, they're there to provide that assistance.
How will you ensure that the changes in this directive are actually implemented and that they have an impact on outcomes?
That's a very good question. So, I mean, it's one thing to, of course, have a directive. It's the other to make sure that we change the culture as well. We have a fairly robust plan around training and education. With our Crown, we've already have started engaging with our Crowns in doing the specific training and education around this policy, jurisdiction to jurisdiction across the province, and we will continue to do that work.
Good. Thank you, guys.
Great. Thank you very much. Have a good afternoon.